Good morning or good afternoon, everyone. Welcome to today's Venable Nonprofit Organizations Group monthly webinar, Employee Benefits, the Evolving Benefits Landscape for Nonprofits. I'm George Constantine, and I co-chair the Venable Nonprofit Organizations practice along with Janice Ryan. Today's program will help you understand how to manage some very complex compliance issues that can often arise when offering the typical array of health, retirement, and other benefit plans to nonprofit employees. I'm really excited. We have two of my colleagues here at Venable who have worked very closely with many of you and other of our nonprofit organization clients over the years with benefits compliance matters. Before I go forward with introducing our speakers today, I'll just make a quick plug for April's webinar. The one in April will focus on nonprofit organization international activities, and the webinar will take place on April 30th. At noon Eastern time. So watch your inbox for the invite for that program. Now on to today's speakers. First, Juliana Reno. She's a partner in our New York office of the firm and chairs Venable's Employee Benefits and Executive Compensation Practice Group. Juliana has worked for years with many employers, including many nonprofits, on all matters related to employee health and welfare benefit plans, advising on matters related to ERISA, HIPAA, COBRA, the Affordable Care Act, and a lot of other applicable statutes, and has been, as many of you may be familiar with Juliana, as she has advised many of you on those issues. Speaking with Juliana is Lisa Tavares, who is a partner in our DC office and with whom I've had the pleasure of working, I think, for about 25 years. She's a leader in the firm here. She co-chairs the business division of Venable, and also in her day job regularly advises clients on ERISA and tax requirements for retirement plans and non-qualified arrangements, health and welfare benefits, fringe benefit arrangements as well. Lisa previously served as a senior attorney in the Office of Chief Counsel at IRS as well. You've got two great experts to speak on these issues. So I'll stop talking and without further ado, turn it over to Juliana who'll get things started. Thanks, everyone.
Thanks, George. Hi, everybody. Lisa and I are going to do a sort of whirlwind tour through the new developments on employee benefits for nonprofits. So let's just get started. Oh, here we go again. Give me 1 second. There we go. All right. A lot of what we're going to talk about today is fiduciary duties because that's where a lot of the developments are happening. We're going to talk about some legal developments also, but this is pretty hot. So first we have to talk about who is an ERISA fiduciary. The 3 bullet points I've got up there at the front that's the technical definition. But what you need to know is that the employer, unless you have specifically named a different fiduciary, if you're silent on the issue, it's going to be the employer. And in fact, it's going to be your board of directors. So if you want it to be, and some do, if you want it to be just a committee and to get rid of the directors, that is probably possible. But you actually have to do that. You have to have governance documents, which again, we'll talk about in a little bit. But the thing that you need to know is if you don't do anything, it's your board. Your board is the fiduciary and they are going to be liable, and they are personally liable for breaches of fiduciary duty. There's some stuff that you can do to take care of that. More there. So fiduciary duties are defined functionally. You don't get to just name them, right? Other than the default, which is, like I said, the board. So the fiduciaries are people who have any ability to control plan assets. Plan assets are any money in your 401k plan, any money in your pension trust. If you have a VEBA trust, those assets, and employee contributions before they've gone. So if you're taking money out of employee paychecks, then basically you have to treat them right or else you get in a lot of trouble. So that's the plan assets one. Anyone who has responsibility for plan administration. What's plan administration? It's a lot of compliance stuff. It's notices, summary plan descriptions, filing your 5,500 every year, things like that. And then there's this other one for people who provide investment advice for a fee or other compensation. That's another whole area. I'm sure you guys don't do that. But I'm sure you have advisors who do. So employers are often ERISA fiduciaries. They often delegate some of their fiduciary duties to an employee benefits committee. That's really common. Employers who sponsor an employee benefit plan are both settlors and fiduciaries. Settlors are the people that set up the situation in the first place, that do all the design, and then the fiduciaries are the ones who carry it out. So that's a pretty high level overview of who is a fiduciary. The point for you guys is it's not somebody else. It's going to probably be you. Lisa, over to you.
Thanks, Juliana. Good afternoon, everyone. So I'm going to break down more specifically what are settler and fiduciary activities. So a settler is in your corporate capacity. We're going to today talk in more detail about what fiduciaries do, but we want to set out the distinction for you as we're talking about the basics of fiduciary duties. So your settler or corporate activities are creating the plan, amending the plan. There might be some sort of corporate transaction in which plans are merged, or you have two different plans internally and want to merge them, or terminating a plan when you're finished with it for some reason. Those are more so corporate actions. The corporate entity is making that decision. So you're not a fiduciary in that capacity. So the fiduciary duties that we're going to talk about don't apply with respect to those settler corporate decisions. Other settler decisions are what I would call design or changes or modifications, features of your plan. So for retirement plans, for 401k plans, that could be automatic enrollment, the amount of employer contribution you're going to have, whether you decide you're going to have a safe harbor plan or not safe harbor plan, what type of medical benefits you're going to have. The plan sponsor in their corporate capacity can still make those decisions. I think of them as the sort of big money ticket item decisions are still in the hands of the corporation. When you move from making those decisions, you move into fiduciary land. When you're implementing what's going to happen next, the day-to-day administration of your plans are fiduciary actions. So you may make that decision about having a safe harbor plan. Once you've made that corporate decision, you then have to make sure your safe harbor plan operates in compliance with the law. So the steps that are necessary, like the type of plan document you have, drafting the plan document, making sure it's accurate, that's part of a fiduciary obligation. Fiduciaries, going back to what Juliana was talking about, are also responsible for the selection, oversight, and monitoring of all of your service providers. So on the retirement plan side, you may have a third-party administrator who is handling your retirement plan sort of on the platform. The contributions go to them. They may provide your plan document also, and they provide generally a website that your employers are going to. Your selection of that provider is a fiduciary decision. And we'll talk in more detail about all the various aspects of those decisions as we go along in this talk today. But the various vendors that are providing services for the plans have to be monitored, both with respect to fees, which we'll talk about, and two, just with respect to the service that they are providing. Fiduciaries also, and probably the most talked about area in terms of fiduciary duty generally, is with respect to investment options. So for retirement plans, for example, while those investments may be participant directed, your participants are going in and selecting investments, they're selecting off of a platform that the plan sponsor is choosing, at least with respect to core benefits. We'll talk about that also a little bit later. But plan investments and being aware of good, bad investments, what's happening in the investment arena are responsibilities of a plan fiduciary. And then with respect to what I mentioned fees, with respect to claims, there could be claims on the retirement side, the vendors are generally handling at least the first level of claim. There may be an appeal or something that is not in the ordinary day-to-day administration of the plan that the third-party administrator, like in it, typically for a 401k plan, is going to be a death benefit or some issue which couldn't be resolved by the third-party administrator. Through the ERISA appeals, claims and appeals procedure, I should say, the responsibility to the fiduciary is to obviously follow the terms of the plan. And then on the health side, they're even sort of more complicated level. As Juliana mentioned, you may hire someone to be your ERISA fiduciary for certain purposes, which we'll get into. And you're shifting some of that liability or responsibility to that party, but there may be appeals in that situation. So this is where all of these duties, which we'll break down in more detail, have to be considered. We can move to the next slide.
Okay, I want to, before we jump into the details of ERISA fiduciary duties, I want to make clear something that was on the first slide, which is that these fiduciary duties apply to retirement plans and health and welfare plans. And welfare plans, so that's how we describe what I spend most of my time doing, health and welfare. What that means in terms of your life is medical, dental, vision, life, and disability. There's other things too, health FSAs, but those are the big ones. So don't take that as exclusive, but that's sort of the universe that we're talking about. Okay, so let's talk a little bit about the ERISA fiduciary duties. This is black letter law. There are 4 ERISA fiduciary duties. They're not optional. There's no debate about these. This is straight up law. The duty of loyalty is to act for the exclusive benefit of the participants and beneficiaries. So one of the ones that gets people in trouble a lot is, this is probably not so much for nonprofits, but let's do it anyway. So you have a customer, Acme, and Acme provides 401k services, and you're providing services to Acme, like you're driving them around, you're a taxi service, right? And then Acme says to you, oh, we want you to hire us. And you're like, oh, well, that would be good for my business. So I should hire Acme to be my 401k service provider. No, you've just picked them because they're good for your business and not because they're good for your participants' beneficiaries. So that's a sort of one that you hear about a lot. The duty of loyalty is very much implicated in a lot of the lawsuits that we will be talking about later. The duty of prudence is to do a good job. That's basically what it is, to be careful, make considered decisions, make sure you, for example, do an RFP. You don't just pick somebody, right? Number one, the duty of loyalty was picking them for a bad reason, but it's equally bad to just pick them out of the phone book. Duty to follow plan documents. This is really important. We get asked once a week if we can make an exception. Our plan document says this, but this person is really having a tough time and we'd like to make an exception. But here's the problem. The problem is that you have a duty to follow the plan documents. Then there's also a duty to diversify. This is an investment issue. This is when you have, especially for a pension, right? You have a duty not to have everything in a high risk fund. For a 401k, you have a duty to have a balanced menu of options. Again, high level, those are your duties, fiduciary duties. Lisa.
Want to spend a few minutes on where we see employers sometimes falling short and what we think you need to be mindful of. Juliana referred to committees. Not everyone has a 401k committee or health and welfare committee. We would love to talk to you about that in more detail. The point today is to make you aware of some exposure, think by not having committees, if you don't already have one. We're going to assume that everyone has at least a 401k or retirement plan committee. Having infrequent meetings, the best practice is generally quarterly, because you get investment returns on a quarterly basis. Some clients do a little less. You want to leave some leadway in your documentation, I think, about committee meetings and how frequent they are, but certainly I think we're all in our practice recommending quarterly. We generally also recommend, if there's an appetite for it, to have a charter which outlines the duties of the committee that will be handling the benefit plans. We're going to talk about documentation through the process and as your role as fiduciaries. But documentation or weak documentation is the source of issues both with IRS and Department of Labor compliance, but in particular is referenced in a number of the lawsuits that we're going to talk about, or is certainly a source of not being able to defend in a lawsuit. So as a risk mitigation factor, documentation needs to be shored up. Delegation was referred to earlier, as I just referred to committees. If you have that board, there needs to be some discipline in thinking about where you want this fiduciary responsibility to sit. Depending on the size of the entity, it may be just going from the board to a committee of the board. The comp committee or governance committee oftentimes has jurisdiction over benefits. As entities get bigger, there's generally a 401k committee that's going to be responsible, or a health and welfare committee. But those delegations need to be written, because otherwise you've just obfuscated the whole purpose of having this committee, if you have not, from a corporate governance perspective, in writing, put people on notice that you've delegated that level of fiduciary responsibility. And that then would be the party that is being sued. Instead of the board and the corporation at the top, we try to isolate fiduciary liability in the smallest body, which is generally going to be the committee. And then today, this is a fiduciary training of sorts for you, but your committees and certainly people with responsibility over benefit plans should be having training.
Okay, so one of the fiduciary duties that we've talked a little bit about is selection and monitoring of service providers. This is for all kinds of plans, all of them. We recommend regular RFP cycles. So we see a couple of things. One is you get a provider that you like and you don't change them for 20 years. Sometimes you do market checks, but you don't really do an RFP. That is not recommended. We recommend RFPs every 3 to 5 years at the most. I work with health and welfare plans, so that's a little trickier because you're doing RFPs for a lot of different vendors as opposed to just your 401k vendor or just your pension vendor. I would say this: do not do RFPs for all of your welfare benefits in the same year. That is crazy. It's way too much work, and it's just very unhelpful, and it's too much change for your employees all in one bundle. So what I would do is I would set up a schedule where we do medical one year, because that's a heavy lift, right? Life and disability the next year, and then whatever's left over the next year, right? So now you're on a cycle, you're doing RFPs every year, but it's not a heavy lift every single year. In that RFP process, you should be getting benchmarks. You should find out what the most important thing you can find out in those RFP processes. What's a regular fee, right? You don't have to pick the cheapest one. That's not required, but your process, the whole process should let you know, are you in the ballpark? Are you way out of whack here? And the same for services, right? Are you getting the services that are generally available and appropriate for a plan of your size and type?
That's a great point, and it applies also to retirement plans, as I mentioned, the various service providers. With the focus on investment options, what the plan sponsor and the committee should be reviewing is, or putting into place, if you don't already have it, is a policy statement about investment. So we'll give a outline of what the committee expects to review, like setting up watch list. What's the criteria if you see that investments you have selected have not performed as expected over maybe 1, 2, 3, maybe 4 quarters consistently? Some investment policies will then say that's time to put something on the watch list. That's a entity by entity selection. There's sort of no right answer to it, but you should not be in a situation, and we'll talk about cases. The key phrase is you can't set it and forget it, is what the case law, some of the cases say. So you want to continue to monitor what's in those investments, and having an investment policy statement that also outlines the criteria of which you may include certain types of investments, real estate, mutual funds, collective investment trust, etc., should be outlined somewhere in writing. And the selection of a share class, we've seen over probably the last 12 to 15 years, there was an explosion of litigation about sort of fees, and then that's now turned into focus on what's underlying in those fees, which is often share class. So retirement plans, particularly 401k, defined contribution plans, should be reviewing and ensuring you're at the lowest share class. If you don't know what share class you're at, then you need to go out and do that today. There's retail share class, there's institutional, which is less expensive, and then there are other options, as I mentioned, collective investment trust. But there are a number of things that you need an experienced financial advisor to help you identify, and benchmarking is part of that process to see where you are based upon the size of your plan and the other investments that are available out there for you.
I added the next bullet just to flag it, because when you are selecting your health plan vendor, most of you expect that the vendor will comply with all the laws for you, and that is not true. They're not being jerks about that. The fact is that the law puts the burden on you in a lot of cases, and through the contracting process, through the selection contracting process, you will want to get the vendor to agree to help you with that, even if they don't take full responsibility for it. One of the best examples is this Mental Health Parity and Addiction Equity Act, which probably most of you have heard of, a non-qualified treatment limitations. It's a whole cottage industry at this point. But the vendors will not guarantee that they're in compliance, but they will agree to help you if you are audited, and they will agree to provide information and things like that. We did get one question that I'm going to take, which is, we recommended regular RFP cycles. Does that include cycling for your broker to select a broker? And the answer is yes to that. You should be cycling. We just did one here at Venable. Yes, you should be cycling through RFPs for your brokers and your consultants.
Yes. Before I get to committee minutes, one point on brokers and consultants and all of this. There are regulations that require the vendors that you're using. Will focus first on retirement plans. Julia is going to talk later about health and welfare plans, but we don't have a separate slide on it, so I want to note it here, given the question, that you should be getting a service provider fee disclosure. Assuming you're going out to RFP, you should be asking those vendors for service provider fee disclosure. I'll just talk about retirement here. That will give you an idea of the fees that they're charging, both at the broker level, but certainly for all the TPAs that are providing bundled retirement plan services. I already referred to the committee minutes and outside expertise. This goes along with what you're going to hear us say over and over and over again about fees and reasonableness and prudence. And I know it's much more difficult in the smaller employer market, but outside expertise, brokers that you're using, investment advisors that you're using, investment managers who sort of work at a higher level than just an investment advisor, they need to be working for you without conflicts of interest. So what I often see in the smaller market is there might be an investment advisor at A1 Bank, and then A1 Bank has, a retirement services arm, but that A1 retirement advisor is receiving a commission or some amount for the advice that they're providing to you as an entity, and you happen to be using the services of a related third-party administrator. There's inherent conflict of interest there potentially. So the service provider fee disclosure, one, should highlight whether or not there's conflicts of interest, but you need to be thinking about potential conflicts and be mindful. Similar to the example that Juliana gave, this is all part of the duty of loyalty to your participants and beneficiaries.
I'm going to hit one more question because another good one, which is what size groups do the guidelines apply to? The answer is any size. Everybody has fiduciary duties. Now, granted, your risk is a lot less if you have 3 people. If you have 3 employees and you don't do a robust RFP process, you have a much lower risk than if you have 10,000 employees. So, but the rules don't distinguish in size. It's just a risk issue.
Mm-hmm. Operational compliance. I want to cover again some things that Juliana and I thought we would highlight, what we see commonly, the things that we deal with, that people call us up on the phone about. Late employee deferrals. The Department of Labor has reported widely this is #1 failure for retirement plans. It can also happen in health and welfare plans, but oftentimes it does not get identified unless you have 100 or more employees and you have an independent audit. It applies, the rules apply in terms of amounts being late. There's a 7-day safe harbor for very small plans, but for most plans, the rule is going to be for whatever the pattern is for you making employee deferrals. That might be the day before payroll because it goes through on a file feed. It might be the same day as payroll, but you need to keep up generally that same cadence. And if there's irregularity or amounts that are contributed later than your general cadence, you're going to run into problems with the Department of Labor and have exposure. And there's a correction program for it, but it's a tedious issue that everyone should be on top of. We often see just errors in the calculation of people's benefits, either based upon errors in the definition of the elements of compensation that are being used to determine benefits. The wrong people are considered for benefits that are available. Those are generally resulting for some miscommunication or misunderstanding about what the plan document says versus what the payroll system is set up to do. So that's something you should sort of be self-auditing on and ensuring that you're getting the right people are receiving the right amount and the right categories of people. And I think I've covered all of those. Juliana, do you want to talk about health and welfare?
Yeah, I think incorrect eligibility files is something everybody understands. You have people who have dropped and that doesn't get into the file. And so you're providing coverage to people who aren't entitled to it. And then you have also the opposite problem. Somebody signed up and they didn't get into the file. So they go and they get their doctor says, wait a minute, you don't have coverage. And that's another whole process. Operational compliance includes the claims process and the COBRA process. That's all some of the notices that I was talking about. Yeah, everything has to say the right things, and it has to be sent out at the right time. Vendors take care of that for you, but again, choosing a vendor is part of your job. I want to highlight the last bullet on this slide, failure to amend the plan documents, and I want to expand it a little bit because it's also a failure to have, in my world, it's a failure to have a plan document. So if you go back to your office and you don't ask for a copy of the cafeteria plan, I can guarantee you that half of you will not have one. You should have one. It's not, fatal. There are no police that are going to come around and arrest you for not having one, but you need to have one. It's what sets the rules. So if anybody has a dispute with you, the rules are settled by the document. If you don't have a document, you have less of you're not as in a good position to argue, here's how it's going to be, because it's not in writing.
That's great. I'll talk a little bit about what are really amnesty or correction programs at the IRS for retirement plans. As I was talking about the late contributions or late employee deferrals, that's under the DOL Voluntary Fiduciary Correction Program. We've talked at a very high level here. We could do a whole nother seminar on what we've discussed on or referenced on conflicts of interest and issues that are breaches of those 4 basic fiduciary obligations. Many of them can be corrected under the Voluntary Fiduciary Correction Program. But if you talk to one of us, we can sort of guide you through what happens most often if you run into those type of issues. On retirement plans, the IRS has had for over 2 decades now a program of voluntary compliance. There's a self-correcting portion, which you can work with the lawyer to fix operational failures, the failure to review the plan document, and for that document to reflect what's happening in practice. You can do that with some effort in making sure you're documenting that corrective process and making sure people are getting the money they're supposed to. There's a more formal process where you go into the IRS that is appropriate, where sometimes an issue has gone on for a very long period of time. I would be reluctant to say under the self-correction guidance that type of error would necessarily work. There are certain types of errors, and if you want to have comfort that you've actually corrected something in the eyes of the IRS, you would generally go in to the IRS through a written process. But there are general principles and a set of IRS guidance that we follow to correct the type of errors we were just talking about, calculation errors, making the wrong type of people eligible. But it's better than doing something in audit or waiting for an audit, because then you're going to have penalties. The beauty of the correction program is that your exposure from an expense perspective is to the correction versus having the IRS having a penalty and then corrective action. By using the program, you should be also limiting your fiduciary exposure under the Department of Labor rules that are tied to the 4 general principles of fiduciary duty that we discussed.
I'm going to do this one really quickly. There is a thing called fiduciary liability insurance. You must have this. This is what protects your board from having they do have personal liability. This covers them. It doesn't automatically cover your board. It covers whoever your fiduciary is. But as we discussed, that's like usually the board. It's also who is ever acting in a fiduciary capacity. If you don't know whether you have fiduciary liability coverage, you should make sure you do. I was saying, go back and ask if you have a cafeteria plan. It's way more important to ask if you have this fiduciary liability coverage. If they come back, whoever you ask, and they say, we have a fidelity bond, it's not the same thing. Okay, fiduciary liability coverage. It covers you if you get sued for a breach of fiduciary duty. That's the most important thing. The The rest is there's a lot of details about the policy. We help people look at their policy. We have coverage lawyers who help people look at their policies. That's all gravy. The most important thing is make sure you have the policy. Okay, so we've been laying a lot of groundwork, and we're gonna move into what are some actual issues that are happening now. Lisa?
Yeah. Yeah, so want to just give you a couple of hot topics that have come up. It's an extension of these general principles. So the Department of Labor has come out a few years ago and said cybersecurity for plans is a fiduciary obligation. I'm sure all of you have seen in the news plenty about breaches. If you have not experienced one yourself, we deal with breaches, cyber breaches at vendors on a regular basis. There is a Department of Labor best practices set of guidelines about what internally plan sponsors should be doing, but more significantly, what vendors should be doing and what plan sponsors should be asking vendors that they're doing. So you should get up to speed on those issues, because that's what's going to insulate you either in a Department of Labor audit and from challenges from your participants if there was some sort of cybersecurity incident. The misuses of personal information and data could be in a breach, but they could also just be from sloppy record keeping or handling of records. So we want to ensure everyone understands that PII, PHI, the personally identifiable information, which you may understand generally in the privacy context for the various state laws that exist, it's tied to that cybersecurity and a general ERISA requirement now that we think the Department of Labor is looking at. Artificial intelligence is being used by third-party administrators. If you do not have robust terms, contracts with those third-party administrators that you're using, you should be asking what they're doing with respect to artificial intelligence. There may be things that you're doing internally too. I think that falls into the category of protecting data generally in those requirements, but you should be educating yourself on what your vendors are doing. You may have seen in the last 2 years or so, among lots of talk about cryptocurrency, there's been talk about whether or not cryptocurrency is appropriate in 401k lineups. In the core menu, there are a couple of vendors out there, one or two vendors that have cryptocurrency in their main lineup. Some of the big vendors were moving toward having that capability. There are brokerage windows which already had crypto exposure, so you should make sure you understand what's available to your plan if it's being used, because the Department of Labor has been focused on those issues.
Before we go on, the questions today are really good. Thanks, guys. We got a question about fiduciary liability and is it the same as D&O coverage? It is not. Remember the slide that Lisa talked about, that where there's settlor functions and fiduciary functions? When you're acting as a settlor, you're acting on behalf of the company. When you're acting as a fiduciary, you're acting to do things for the plan. Fiduciary liability coverage is specific to actions taken for the plan. D&O covers settlor things. You don't get sued for settlor things, but D&O coverage covers non-plan things that you do in your capacity as a director or officer. So they're not the same. You need both. I'm going to skip past this slide because we talk about all of those things coming up.
Mm-hmm.
Why is ERISA litigation important now? There's a couple of things. For a variety of reasons, ever since the Obama administration, there have been fewer and fewer regulations, and frankly, less enforcement. That's mostly a budget issue. But there are also some philosophical issues behind there. At any rate, a lot of enforcement is now happening through litigation. And that creates more expectations. It's a cycle, right? There's more litigation, so people expect more, the participants expect more. So that's one generation thing that's generating more litigation. SCOTUS, the Supreme Court, reduced the threshold. I've got a whole slide about that. in a minute. A couple of big laws are being implemented. That's another piece. So that's why it's all happening now. Why does it matter? We've talked about this already. Fiduciary liability exposure is personal exposure. It matters because it's now a lot of money, frankly, because there's more and more class actions, and the settlement value, even you're not going to lose, right? You're going to settle, and that's going to be expensive. And in conjunction with that, if you are accused of not doing a good job with something, right? You didn't negotiate a good contract for whatever, then there's some reputational risk, right? That is not what you want to have out there in the news about your company. Cunningham, oh wait, that's me. Okay. So this is the Supreme Court case from last year. There is a part of the law that we deal with every day as ERISA. There's a part of the law that says if the plan contracts with a service provider, like think about your 401k service provider or your health plan provider, your Aetna, your Cigna, whoever it is, that contract is a prohibited transaction unless the fee is reasonable, right? That's sort of a baseline rule that we've all been dealing with for years. For years, when you came into court and said, this is a prohibited transaction, they didn't do it right, the plaintiff had to allege that there was a contract and that the fee was unreasonable. In Cunningham, the Supreme Court said, no, there are two sections to the statute. There's the prohibited transaction section and there's the exceptions section. And so all you need to do to get into court is allege that there's been a prohibited transaction. And you have to do some other technical stuff, but you no longer have to allege that the fee was unreasonable. So we, Venable, and on behalf of our clients, are very worried that this is going to open the floodgates. It is going to be harder to dismiss claims right at the outset because the plaintiffs don't need to know whether the fee was reasonable. They don't need to prove anything. They don't need to have an expert that says it's an unreasonable fee. They can just say, you have a contract, now you prove the fee is reasonable. Okay, now you see why all that work of doing the RFP is even more important than it was 2 years ago. So it really, really is a sea change. I will say there is a bill to change that result that the House Education and Welfare Committee the bill just passed out of committee. I don't know what's going to happen to it. The counter argument is, oh, you're making it hard. You want to make it harder for employees to get their money. So it's not obvious that this is going to get through. We just don't know. So this is, again, Cunningham. It's all about the Supreme Court has opened the floodgates for litigation involving service provider contracts. Lisa, you're on target date.
Yeah, target date funds. So this is related to the investment options discussion we were having earlier. And I wanted to just give you these key factors to consider. But at a broad level, target dates are now in most plans that I work on. They're very heavily invested in 60 or 80% of the plan population will be invested at least in some portion of their account balance in target date funds. As this increase in target date funds has over the last 2 decades or so happened, the litigation has increased. And the issues that come up is whether or not the glide path that has been chosen is appropriate for the demographic. Is there too much risk near retirement in the type of investment option that was elected? Whether the plan sponsor has considered active or passive fee comparisons and the selection of the target date fund. There could be a mix in the fund. Some target date funds are custom designed on a larger platform. You can go to the large third-party administrators and either use their product or you can custom design something, presumably based upon the advice of an investment advisor who would help you come up with that raises questions about what the sort of, I would call the back end fees are related to those target date funds, whether the actively managed funds are achieving better returns than passive. There's a lot of talk about passive, particularly in the last few years, given the market having been being more successful than some of the actively managed funds. They're the same questions we've given you an overview about potential conflicts of interest. If you're using a proprietary fund of a vendor, you want to make sure you understand that fund option in comparison to what's out there on the market. So if you're going to ABC Big TPA, you should be doing benchmarking in comparisons of their proprietary target date funds that are out there. And also documenting the process that you're going through, the evaluation, what you evaluated, among the things that we talked about, for example, benchmarks, and not just picking a target date and leaving it there. You need to continue to monitor that target date fund as you're moving forward. The target date is likely the qualified default investment for a 401k plan. So anyone who's not making investment elections is automatically going in there. That increases your exposure. I think in terms of monitoring and ensuring that you're paying attention to what's in those target date funds. I'll talk a little bit about plan forfeitures. So we could do a whole webinar about plan forfeitures. Here's what you need to know. For many years, I guess probably really back to the beginning of ERISA, so you can see there's a revenue procedure from 1971 that talks about the ability for a retirement plan to reduce employer contributions based upon forfeitures that were left in the plan. There could be forfeitures based upon the fact that you have employee turnover and people are leaving before they vest in their retirement benefits. People have been doing this. There's certainly IRS guidance that says that it's fine. We don't have any contrary Department of Labor guidance, but we have had some really crafty plaintiffs lawyers who have now come up with this argument that the use of forfeitures by the employer is somehow breach of fiduciary duty. It's back to this loyalty discussion we're having. You might pick up, I'm not a fan of this argument. I think it's ridiculous, but it's out there. There have been more than 30 class action lawsuits that are out there. The courts have been generally favorable to employers on this point so far, but different theories are continue to be used in these cases. And the way litigation goes, more than likely, someone will find a theory that works, and that will become a problem for lots of plan sponsors. If you have a prototype document, meaning you just have the document that your TPA gave you, most likely it gives discretion between allowing forfeitures to go in to be used for employer contributions. It may also say that you can use them to reduce employee expenses and also allocate them to participants. That's too much discretion in the environment that we're dealing with. So my takeaway for you is to go back and look at your plan today and see what it says about forfeitures, and consider having a very clear rule about how they're being used, because it's at least now as the case law stands, it's the discretion to choose between different options that is propelling this claim that, well, you could have picked to allow those amounts to be allocated to participants. So just take that out as one of the criteria. And we think that should provide some insulation until the court or regulatory guidance comes out and says something different. I think at this point, we want to make an announcement for CLE purposes about Landscape 2026 is being the CLE code. Landscape 2026. So Juliana, I guess we could try to pick up in
Yeah, I'll do
these
this.
next two slides and then whiz through.
Yeah, I think so. Okay, so first I have to explain when the plaintiff goes into court and sues, the first thing the defendants will say, that's the plan, right? Participant sues, says you didn't do something right, you breached your fiduciary duty. The first thing we do is we go into court and we say, I'm going to move to dismiss, get rid of this case because X. And the first X that you use is this person wasn't actually hurt. They don't have standing, right? Then the next X you use is they don't even if they were hurt, this isn't a claim that y'all should be listening to because it's not recognized. All right. So what's happened in this PBM litigation where the plaintiffs are coming in and saying there is a problem with the prescription drug plan, the prices are too high, the selection is too bad, whatever the problem is, it's usually the prices, right? So there are 3 cases that were dismissed for lack of standing. Those are the first 3. Stern versus JP Morgan Chase the court said there is standing. So on the first 3, they never got to the question of was there a fiduciary duty because the people weren't hurt, is what the court said. And the last one, they said, okay, you're hurt. And they actually reached the fiduciary duty question. So these legal points, the first 2 are in all of them, but really these are all from the JP Morgan Chase case. So the plaintiff said, the drug prices are too high, that gives me a higher premium. The court said, no, that's not enough of a 1-to-1 rule. Like we can't say how much, no one can tell you how much that higher price affected the premium. That's not enough harm that's directly showable. The next thing they tried was high drug prices. I had more out-of-pocket expenses. So the first person didn't have any out-of-pocket expenses because they had already met their deductible. Then the next thing they tried was they just compared the most expensive drugs to a benchmark, and the court said no, that's not enough. And then the last thing they did is they did everything on the formulary compared to the benchmarks, and that is what got them past standing. If you do all the drugs in the formulary. That's I don't know that'll work anywhere other than Southern District of New York, but it worked in the Southern District of New York. So then they go on and they say, well, so it allows excessive drug prices. That alone is a breach of fiduciary duty. And the court said, no, it's not. Setting prices is a design issue. It's a settlor function. It's not a fiduciary function. It goes back to that initial slide we did right at the beginning. Then they said, well, the plan entered into a contract with the PBM. That's a prohibited transaction. And the court said, yes, Cunningham says that is enough. You may continue. So that case did not get booted, and it's because of Cunningham. But more broadly, you need to know that this is how the plaintiffs' firms work, right? They try this. If it doesn't work, they try that. If it doesn't work, they try that. They have a lot of clients, and they're just going to keep nudging till they start knocking down those barriers one at a time. And the further they get, the more likely they are to get a settlement, right? That no one's going to settle until you at least get past a motion to dismiss. That's just, you can take that to the bank. These are absolutely fascinating. 4 cases filed in December of last year. And they say basically, these are not valuable products and you are bad employers for offering them to us. That's really the bottom line of these. Like, you didn't negotiate reasonable premiums because they have excessive loss ratios. What does that mean? That means that for every dollar in premium, they're only paying out 60 cents in claims. And the other 40% is going into their pocket. So you didn't have enough of a competitive bidding. You didn't have reasonable premiums. You gave too much to brokers. You failed to monitor the loss ratios. So I don't know. This is just the beginning. And again, on this one, they're going to try to get past standing. Then they're going to try for the breach of fiduciary duty. All right. We've got 4 minutes, and we're going to go. Lisa, which
I'm going to talk. Yeah, I'm going to talk about these regulatory changes for retirement plans, and then we're going to go through a couple different topics, and then presumably everyone has access to the slides. We've spent time talking about the basics of fiduciary duties, giving you like the tools and the process to think about things. Now we want to talk more about compliance and focus on, the topic or the title for today was evolving changes. There have been significant regulatory changes around sort of this fiduciary framework, things that we thought we knew about over the last several years. So some of them have been more recent, but some of them test longstanding rules. So there was an executive order last August that has stated that there should be more access to different types of investment options in 401k plans. So I talked earlier about target dates and we talked about core menus. Oftentimes core menus are made up of just mutual funds, and they may be in different categories. They may have some international exposure, small cap, large cap, mid cap. But now there is clear guidance under this executive order, not the Department of Labor, who's had jurisdiction for these issues since the beginning of ERISA, that there should be recognition of the use of different types of investments, including real estate, hedge funds, things that define benefit plans have been invested in, but making those options available and giving plan sponsors some comfort that those options should be available in a 401k lineup. That's something you should be discussing with an ERISA lawyer, I think, in detail if you're thinking about those types of options. ESG and DEI. This has been sort of going back and forth. The pendulum has shifted over the last 10 or so years with respect to the type of investments that the Department of Labor was indicating were appropriate. There had been sort of a swing toward, yes, plans should be considering ESG. There's an executive order that came out in December, which very clearly directs the Department of Labor to issue guidance that says you should not be considering ESG or DEI factors in 401k plans. And there's been a number of cases over the last almost 10 years on very similar issues related to ESG and whether or not it's appropriate in plans. So you need to educate yourself about those things. And finally, there's a long battle that's been going on for over 15 years on the definition of the fiduciary rule. Juliana and I talked at the beginning about where the law started. ERISA came out in 1974 based upon general trust principles. Fast forward to the last 15 years or so, there's been an attempt as the market has changed, as people move more between plans because they're changing jobs more often than they were in the past. The rollover market is huge, either between jobs or people retiring now with bigger nest eggs, and there's significantly more money in 401k plans than they were at the beginning of ERISA. So some prior administrations try to put some guardrails or additional fiduciary duties on the parties that give advice, it's mostly as people are coming out of plans, also with respect to the investment advisors that I was talking about before, who may be helping you set up your lineups. You need to talk to those people about whether they're representing you in a fiduciary or a non-fiduciary capacity. But with respect to people that are trying to roll out of a plan, they call up XTPA or brokerage firm, and they say they're going to move plans, and they get advice regarding those rollovers. And there were attempts by prior administrations to make that fiduciary advice tied to the same duties and standards we've been talking about. Well, we've gone back in time, back to the past, I guess, back to an old test about what are fiduciary duties generally, which are similar to the duties that we've told you about before. But basically, anyone who's receiving who's providing advice, they're receiving a fee, and someone is going to rely upon that, sits in a fiduciary capacity. That's a very general standard rule that goes back to 1975. And so we've seen the pendulum completely switch to, I would say, some activism and protection of employees and individuals, and switch back to sort of an older standard. The next, oh, you want to talk about Trump accounts, and I'll
most of the stuff that is the rest, you can mostly figure it out based on the slides. So if you have to go, then feel free to go. The only point I want to make about Trump accounts, you cannot make any contributions until July 4th. There is an ability to make pre-tax salary contributions, either salary reduction contributions or employer contributions on a pre-tax, tax-free basis. To do that, you need to amend your cafeteria plan. Right now, my clients are not asking to do this mid-year. Most people are waiting, partly because we don't have regulations explaining how that's all supposed to happen yet. Where are you supposed to send the money? Do you have to have an agreement with 5,200 million different banks? How's that all going to work? Most of my clients right now, if this helps you, are saying, we look at our cafeteria plan in December or November for the next year. We're not going to do something mid-year. So that is an option. You can do it mid-year. You certainly can. But again, the pre-tax or tax-free stuff, that has to be written into your cafeteria plan. Lisa, what slide do you want to do?
If you go to 22, I'm going to talk very generally. So we talked about a fiduciary responsibility being following the plan document. Well, your plan document has to be updated and comply with the law. So if you're using a third-party administrator, they presumably are providing you with documents, or you would use a lawyer. We help create and amend documents for clients. That's what we do day to day, but that's in order to comply with the law. The failure to timely amend documents is a fiduciary failure, but it has consequences on the IRS side. That correction program that I talked about, if you don't amend your plan in time, on a retirement plan side, you can go through that correction program. But I would say 40% of the time I spend is fixing problems for people that have happened in these plans. There are a couple of deadlines. There's a bunch of guidance that came out of Secure 2.0, but a couple of deadlines in particular that are listed here. There's slides attached to them. So we just wanted to raise those as, again, things that we saw footfalls with. And mandatory Roth is sort of the biggest thing that we think people are struggling with, and that still has an amendment deadline of 2027. So you can keep going, Juliana. I think I was going to the only one I need to talk about is the one at the very end. Do you want me to? Go ahead.
Let's do that. So mental health parity, it's not one and done. Service provider fee disclosures, there's a big fight about the effective date. PBM contracting, we talked about, try to protect yourself. This is the one I wanted you to get. Everybody figured out how to avoid ACA penalties when those penalties came out. That was 10 years ago. If you have not revisited your assessment of your ACA penalty strategy in 10 years, now is a good time to do that, right? We've just gotten through 1 year. So who you are covering, how you are making sure that you avoid the big penalty by covering full-time employees. How are you defining full-time employees? How much are you contributing? Are you trying to make sure that it's affordable for everybody, or does it make more sense, given your population and job, to make it affordable for most or some or none? There's lots of different things here. The penalties apply they apply to you in 2026 if you had at least 50 full-time equivalents in 2024. It's a calendar year test. So if you had 20 employees last year, you don't have to worry about this. If you had 100 employees last year and they are mostly full-time, you are probably going to have to worry about this. So I need to tell you that the CLE code, again, is Landscape 2026. The slides will be available through the magic of the internet. an email. Our elves send them to you, I guess. And of course, Lisa and I are available to discuss anything you've heard today, because that's what we do. Thank you so much for your time.
Thank you.